I'm Drew Stevenson, and this is a lecture about the case Ethyl Corp versus Environmental Protection Agency, or EPA. This is a case from the DC Circuit Court of Appeals from 1976, and it's about the judicial review of agency rules and competing approaches to the arbitrary and capricious standard. Now, for my students, this is not necessarily binding precedent today because it's not from the US Supreme Court, although it's from the very influential DC Circuit Court of Appeals. It's in your casebook, not because this is one of the big cases that we have a doctor named after, but so that because it's such a great teaching case that we have concurring and dissenting opinions and the majority, that where we have some of the finest legal minds of that era who understand the same standard of review differently and explaining what arbitrary and capricious review means to them for judicial review of agency actions. And so it's in your casebook to help you really get a nuanced understanding of the different approaches that courts can and have taken about the same standard of review outlined in the Administrative Procedure Act. So having said that, let's go back to the case. So the EPA, acting pursuant to its statutory authority, adopted a rule to phase out lead in gasoline. So in the old days, they would add lead as an additive to gasoline because it helped resolve engine knocking or made the engines in cars run more quieter. And this was phased out in the late 60s, early 70s. And the EPA's decision was based on its own 3-year study that lead in gasoline exhaust fumes posed a significant risk to human health, particularly among children in urban communities. So lead can cause cancer, right? It's very bad and brain damage. It's bad for you. And what would happen is they would put it in the gasoline. The cars would run better, the engines run better, but then we have airborne lead come out in the exhaust fumes, and in areas where there's a lot more air pollution, like congested urban centers, there would be a lot of lead in the air that would have an effect on people's health. So the lead industry wasn't having it. They were upset because they made a lot of money selling lead to the gas companies to add to their gasoline. So they had fought the regulation tooth and nail during the rulemaking process, and now they turned to litigation. The lead industry had a variety of arguments. First, they challenged the EPA's conclusion that lead additives in gasoline posed a serious threat to human health and the environment as arbitrary and capricious. They are basically saying the agency kind of pulled this out of thin air and didn't really study it enough. They also attacked all of the agency's studies at the same time, pointed out evidentiary or logical gaps in the agency science, and they had their own scientists who did their own studies saying that lead in the gasoline couldn't hurt people. So the first time this goes to the DC Circuit Court of Appeals, we have a 2-to-1 decision, and they found that the EPA had acted arbitrarily and capriciously. So they sided with Ethyl Corp. The panel found that at several points, the EPA's conclusions were not supported by scientific evidence or sound reasoning. So we get a rehearing and back. And so, and ultimately the EPA won over a dissent by Judge Wilkie, who had written the original panel opinion. So from a procedural standpoint, we actually have 2 DC Circuit decisions about this, and the judge who wrote the majority opinion in the first one, it loses during the en banc, loses a vote, and is writing the dissenting opinion in the final decision that is in your casebook. So Judge Wright writes the majority, and he says the standard of review under 706(2)(a) is highly deferential, and the agency action should have a presumption of validity, therefore. Even so, This doesn't mean that that the court is rubber stamping everything every agency does. If it did so, then appellate review would be superfluous, but still time consuming. So a completely waste of time. So he says, the majority, Judge Wright, that a reviewing court should focus on whether the agency decision was based on a consideration of the relevant factors. And this is kind of a rational basis test, and the inquiry involves substantial, searching, and careful inquiry into the facts, especially in a complex case like this, which is about toxins in the air and whether and to what extent they affect human health. So the majority opinion and concurrence by Judge Leventhal, who is kind of famous, seemed to adopt the view that judges should adopt a presumption in favor of the correctness of the agency decisions when they're applying arbitrary and capricious. Remember, this is different ways of understanding the same standard of review with these different judges. So some of them think that this is a presumption of correctness and should be very careful not to substitute their own judgments about wise policy for the views of the agency. In other words, Congress wanted the agency to make the rules, not the courts. At the same time, they add, judges do need to immerse themselves sufficiently in the substantive issues to understand whether the agency's analysis and treatment of the evidence passes a minimum threshold of reasonableness. In other words, even though these judges aren't scientists and don't know everything about lead itself or the chemistry involved or the biology of how it affects the human body, they're educated, right? So they can read the briefs and listen and at least make an assessment about whether the agency is doing its job and considering everything. So this is substantive review, but with a very low rational basis standard. In other words, they're not going to substitute their own policy preferences for the agencies, but they're going to look at the evidence just enough to make sure that the agency's decision, whatever it was, meets a minimum threshold of reasonableness. So it's possible that they could throw out what an agency did if it seems truly unreasonable. Now, Judge Wilkie, who writes the dissent and had written the majority opinion the first time around in the first lap, let's say, he uses a lot of the same rhetoric, but his approach is more demanding. He wanted a more judicial scrutiny or a little more activist court to keep the agencies in check. So he thinks courts should make agencies fully explain and defend every link in both the evidentiary and logical chain leading up to the agency's decision. In other words, he wants to see the evidence and evidence of the process of decision. So I think of this as a parallel track approach or two-track approach to arbitrary and capricious review. First, we want to see the weight of the evidence you considered just to make sure that you weren't flipping a coin or something like that, but we also want to see how you worked through the process of reviewing this evidence. In other words, show your work, as maybe one of your math teachers told you in another phase of your life. We want to see how, did you have meetings? When did you read reports? How did you rule out alternatives? How did you narrow down the questions and so forth? And the court feels competent, he thinks the courts are competent to review decision-making processes for institutions or and bureaucracies like administrative agencies. And he says judges can't give the agencies the benefit of the doubt when there's steps in the argument missing. Now, we have a concurrence from Judge Bazelon, and he says that judges should not conduct substantive review of the merits of agency decisions, at least in complex technical areas. So he's saying, look, Congress, we're judges, right? We were lawyers and we're jurists, we're not scientists. So we know a lot about procedure. So judges should focus on procedural review and approve agency actions but only if the agency used decision-making procedures that were adequate given the nature of the decision at hand. In other words, now this may sometimes mean adopting procedures that go beyond what the APA seems to require. So he is very focused on just the process, not the substance, unlike Judge Wilkie. But he's so focused on it that he thinks that there's going to be a sliding scale of how much process is required depending on how important the decision is and how controversial it is. And if you're watching this in conjunction with Vermont Yankee, that other case, that is an idea that's the Supreme Court finally rejected in the Vermont Yankee case, is the idea that in certain special cases, judges could require agencies to go through more steps in their decision-making process. So keep in mind that the Supreme Court weighed in on these questions in the 1970s and early 80s, and they seem to have resolved that, as I said, the Spazilon-Leventhal debate in the Vermont Yankee decision. In other words, not to get too far off track, but in that case, the Supreme Court said, judges, if the agency is fulfilling the requirements of the Administrative Procedure Act procedurally, courts can't add on more procedures that they have to follow besides what Congress has stipulated. On the stringency of review issue, which is the real debate between the majority opinion and Judge Wilkie's dissent, the Supreme Court's State Farm decision is the most important case in that area about how much scrutiny we're going to apply. And ultimately, they settle on sort of this hard look review where they're going to scrutinize whether and make the agency show that they really did work through a careful process and weighed alternatives and eliminated them systematically. Okay, that concludes our lecture about the Ethyl Corp case.